Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. Honorable Supreme Court of India, two judges bench, Justice B.R. Gawai and K.V. Vishwanathan. In the Sumoto case or on the bunch of writ petitions filed against the bulldozer justice yesterday, they have delivered a trustworthy or beautiful judgment. The case lies in re directions in the matter of demolition of structures v and others. Directions in the matter of demolition of structures v and others. Writ petition, main petition number 295 by 2022, decided on 13/11/2024 by the above named two judges. They held that bulldozer justice, please remember bulldozer justice, that is demolition of a house or structure of a person who is involved in a crime, it is amounting to collective punishment to all the members of the family. In a structure, families may reside. In a house, family members, not only the concerned person, but other members will reside. So therefore, it is becoming a collective punishment for them, which is highly deprecated by the Supreme Court, and the Honorable Supreme Court of India was pleased to give a slew of directions, out of which I am going to touch only the important directions. Here, the genesis, please remember, the genesis you may be knowing. Very recently, our Deputy Chief Minister Sri Pavan Kalyan also stated that the law and order should be like that of Uttar Pradesh or bulldozer justice. So, in general, what happens is, if any person is committed in a heinous crime, his house will be razed to the ground with a bulldozer, maybe on some other ground. So, not that he is involved, they say that it is not built up in with so-called permissions. Without permissions, setbacks are there, they did not leave the setbacks, or the place itself is an encroached thing like that. But basing on some allegation, the destruction or demolition is 100% correct. So this is actually not liked by so many civilians of the society. They have filed number of writ petitions, and very recently Honorable Supreme Court of India also clearly directed the UP government, who filed the counter affidavit. Of course, they were pleased with the counter affidavit, but they said that if you want to go for demolition, please take our permission till we decide the case. On 13/11/2024, they have decided the case basing on Article 21 of the Constitution of India. Article 21 says the state has to protect the life and liberty, personal life and liberty of each individual of a citizen, except as per the procedure established by law. So, right to life is a fundamental right. So, right to life includes right to live. That means includes right to shelter. In Bombay Municipal Corporation case, we have very clearly said that right to live is a fundamental right. Right to shelter, it is the duty of the Bombay Municipal Corporation, Volga Telly's case. You have to provide the alternate accommodation. Like that, Supreme Court observed that demolishing houses on the ground of involvement in the crime is impermissible. So, Article 21. So, if the authorities are permitted to demolish a structure or a house, they are removing the shelter from the heads of persons who are not directly involved. Only one person might have, what about the others? They might not have been directly involved. So, this is against to the settled principles of jurisprudence that the person should be considered innocent till the guilt is proved. And they have cited a beautiful case law and the Iyer doctrine, V.R. Krishna Iyer, late V.R. Krishna Iyer Justice. In the case of Gujarat Steel Tubes Limited and others, Gujarat Steel Tubes Limited and others versus Gujarat Steel Tubes Mazdoor Sabha and others. So, there he tells that we reject the theory of community guilt and no boss, no public can be punished except for his own guilt. That means the person who is responsible must only be punished and not the group. So, beautiful case law have been cited, and actually the judgment started with the famous quotation of Justice Lord Denning in Southam versus Stout, 1964. So please remember, in this connection, various directions were given. I will complete one or two. Workforce, these directions will apply to the so-called demolitions which are not encouraged or so unauthorized structures, if any constructed, they don't get any directions. So if they are trespassers, if they are unauthorized builders, definitely they can be demolished following the due procedure. This is very, very important. So here the caution given to the police is, the police are not the judges. They should not act like judges. Basic point. If they commit or if they do any demolition without following the procedure established by law, they are liable to pay compensation and also punishment. Don't behave like judges. Right? So 15 days notice has to be given. Notice has to be given first. If you want to go for demolition, you have to give a notice to the party and you have to give time of 15 days. For what? For hearing his grievance. You can personally hear him also. Then only you have to take a decision. Then no demolition early in the morning and after sunset. Even knowing in Hyderabad, Hydra, they used to go at 4:30 or 5 a.m. and demolish all the structures. It's not allowed. So no demolition in the early hours and in the late night also. And please remember, account will be there on malfeasance of the authorities. You know, I told you misfeasance and malfeasance. Misfeasance means not acting. Malfeasance means acting in a malified way. ఏంటంటే తెలుసు మీకు అది, కానీ ఎందుకు శుక్రవారం చేస్తారు, డిమాలిషన్ ఎందుకు చేస్తారు, శని ఆధారాలు సెలవుగాడు. దిస్ ఈజ్ నథింగ్ బట్ malfeasance. Then if demolition వీళ్ళ మధ్యలో, if somebody goes to the court and gets an order against the demolition, the comp should be stopped, and for the already demolished structures compensation has to be paid. So number of guidelines were given, 95 pages judgment. Anyway, since if I tell you entire time will be over, these are the important directions given to the authorities, and Supreme Court highly deprecated the demolition of a house for the sake of one person involved in a crime. You cannot demolish his house because many others will be residing. It will be punishment for the others also. It should not be. Even rowdies, when we youngsters, we used to tap the doors of the house in the early hours and ask, I could not dump him. Then if he goes to the court, then they said, right to life, right to privacy. He may be a rowdy, he may be a DC, he may be a KD, but he has got his own life. You can't disturb him in the nights. Then we said, we have got provision under the police manual that we can check the rowdies. Then they said, go through your APBM. Then we have gone through. It is very clearly stated that you can keep only unobtrusive watch. That is, without his knowledge, you can watch his movements. So like that, right to life has been extensively discussed in this particular case, and number of directions were given. If you find time, please read the case law. Of course, bit by bit, because lengthy case law, Directions are also bit by bit. So please read it and enrich your legal knowledge. Thank you.